in the name of personal injury law.
The no-fault reforms of 2019 have been controversial. While some support these reforms, many others have concerns about the fairness of the reforms and the impact on the medical care rights of those injured in auto accidents. Some of the most concerning aspects of the reforms have just taken effect or are about to take effect this July. We have Steve Sinas and his law partner, Katie Tucker from Sinas Dramis Law Firm to talk with us about these changes. It's great to have both of you here.
Thank you. It's great to be with you, Lisa.
Thanks so much. It's great to be here.
So we're going to talk about your concerns about the three different ways the 2019 reforms may impact the rights of patients under the no-fault system. My first question is whether these changes are going to apply only to those injured in accidents now, or do those changes apply to even those people who were injured in accidents before the law changed?
So we're going to talk about three issues here today. The first issue is how the law drastically reduces payments to medical providers. We're also going to talk about how the law drastically limits the rights of people to receive in-home care from their family members and friends. And we're also going to talk about how the law creates new complicated ways that the government can regulate medical care rendered to those injured in auto accidents. So those are concerning changes to us, and we're going to explain that in this episode here today. But let me first start by answering your question. And the answer to your question is these rules are intended to apply to everybody in the system. And we think this is an unfair aspect of these laws because the people who were claiming benefits under the old law bought an insurance policy from their insurance company that was based on the old rules. And now the legislature comes in and changes the rules, and the law says it's supposed to apply to everybody. And our firm is pursuing a lawsuit over this issue where we're seeking a ruling from Michigan appellate courts that such a law is unconstitutional because it infringes upon the contractual rights of consumers in terms of the policy they bought and their rights under that policy. So all these rules that we're going to summarize here today are intended to apply to everybody. And that seems to us, at least, to be a great element of unfairness.
So what about the payment reduction to the medical providers who treat those people injured in auto accidents?
Yes, Lisa, as Steve mentioned, one important way that the reforms will adversely and unfairly impact auto accident victims is that the new law drastically reduces reimbursement to their medical providers. Under the old law, a medical provider was entitled to reimbursement for all of its reasonable charges for treatment rendered to individuals injured in auto accidents. Now, under the amended law, starting July 1st, 2021, just a few months from now, a provider's reimbursement will be significantly reduced from current levels and subject to new statutory caps. In fact, for many providers, reimbursement will be capped at 55% of what they charged under the old law. This drastic 45% cut in reimbursement will effectively force many providers to limit the number of auto accident victims that they treat or to stop providing treatment altogether, thereby restricting access to care to many injured persons across our state.
Okay. Does the 2019 reform limit the rights of injured people to receive in-home care from family members or friends? And if so, how does that law do that?
So when somebody is severely or catastrophically injured in an auto accident, they have their hospital care and they're released from the hospital and they go home and they need in-home care. And under the original law, these people were able to form agreements with their family members and their friends to come over and provide them the care they needed. That was a level of comfort to them because they knew these people cared about them, and these people could go about providing this care by being paid by the insurance company. So if they had to take time off of work and rearrange their lives to provide the care, these people could be paid. The new law says that if somebody is your family member, your roommate, or your friend, they are limited to 56 hours of payment for care rendered each week. They cannot be paid for anything more than 56 hours. So if somebody needs 24 hours of care, what it comes down to on average, they can only have their family members or friends be paid to render 8 of those hours. They then have to turn to the outside world, to strangers, to commercial care to get the extra 16. We wondered why was this the case? Why did the legislature choose to limit the people who could actually provide care for people? And it's befuddling to us, it's concerning to us, and it's certainly going to be something that those who have been used to their family members and friends providing care are going to be in for a rude awakening when they find out that they no longer can be paid and they have to start getting care from strangers. So we also are concerned about this aspect of the law.
Well, Steve, I'd like to follow up with your comment. Isn't it actually going to cost the insurance companies more money by having to add the 16 hours of out-home care by some professional to make up the difference for those people who actually do need 24-hour-a-day care?
It could. Now, the insurance companies can try to agree to pay more than 56 hours to family members or friends, but it gives them all the leverage. This is an anti-consumer type of provision as far as we're concerned. When it comes down to it, people should have the right to choose who their care providers are. They shouldn't be told by their insurance company who their care providers should be.
And that's particularly true when the people are coming into their home with their family, right, Steve?
That's right.
Okay. And then how did the 2019 reform increase the power of government to regulate and potentially interfere with the medical care of people injured in auto accidents?
Thank you for that question, Lisa. As Steve mentioned earlier, again, the reforms will lead to increased governmental regulation and interference in auto accident victims' ability to access medical care through a process known as utilization review. Under the old law, decisions about the type and amount of medical care and medical treatment that an auto accident victim needed were left in the very capable hands of their doctors or other providers. When disputes arose, a patient could challenge an insurer's denial of treatment by filing a lawsuit in a Michigan trial court. Now, under the amended law, decisions about the type and amount of treatment that the auto accident victims need and receive may actually be made by a governmental agency, the Department of Insurance and Financial Services, through the new utilization review process. Importantly, patients have absolutely no role in this process. And although patients can still file a lawsuit to recover unpaid benefits, decisions may be made before they can do so and without their involvement. The only entities involved in the utilization review process are insurers, medical providers, and the Michigan Catastrophic Claims Association. The process is governed by a set of rules developed by DIFS, the Department of Insurance and Financial Services, that are cumbersome and extremely complicated. To learn more about the rules and the process, please check out our utilization review page on autonofaultlaw.com. And just following up on a point Steve made earlier, Lisa, all of this just goes to show how unfair this new law is, especially for those injured in auto accidents well before the law took effect on June 11, 2019. As someone who might be injured in an auto accident today, those who were injured before the new law took effect their claims will be subject to this utilization review process. And so for many of these people, for decades, they were receiving and able to access care without governmental interference, without governmental regulation. And now they are going to be subject to this new UR process, these new rules, and this additional layer of administrative bureaucracy when they're trying to access care that they desperately need.
So just to recap, because we've shared a lot of information today, Steve, could you just give us a quick recap of what parts of the law have already gone into effect and then what's coming just around the corner?
Right. So let's not lose the forest for the trees here. One of the major features of this law is it took away the lifetime right to medical care through the no-fault system for many people. This includes even children whose parents buy a less than lifetime policy. It includes a lot of people who would normally have received lifetime care, and under the reforms, they're going to be capped and only have so much money available for their medical care. And what we're talking about here are all the other ways in which this law takes away the rights of patients and limits them in terms of how they can get their services paid through insurance. And these are the concerning matters that we wanted to bring to the viewers' attention today.
Thank you both, Steve and Katie. And can you tell us that website again?
Yes, Lisa, it's autonofaultlaw.com. We encourage you to check it out.
Thank you so much. Have a great day.
Thanks.
You.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.